effective and more accessible. At the same time, it is important to adopt these technologies with care so that the fundamental principles of due process and, most importantly, the human element remains. To explore all of these issues, we are honored to have with us a distinguished panel. Our chair for today's session is Honorable Mr. Justice Vikram Nath, Judge of the Supreme Court of India. Justice Nath is recognized for his leadership in judicial reform, particularly when it comes to technology. As the Chief Justice of the Gujarat High Court, he championed the cause of innovation in technology, including the setting up of e-Seva Kendras to ensure digitization and accessibility. He also holds the distinction of being the only Chief Justice who allowed live streaming of court proceedings on YouTube and has recently urged the Delhi High Court to follow suit. Justice Nath is also the chairperson of the Supreme Court E-Committee, which has initiated various measures to ensure that adoption of technology results in greater judicial efficiency. We could not have envisioned a better chair for this session, and we are truly honored to have him here. Please join me in welcoming Honorable Justice Mr. Vikram Nath. Our next panelist is Honorable Mr. Justice N. Anand Venkatesh, Judge of the Madras High Court. Justice Venkatesh is known for his forward-looking and reform-driven approach. His judgments have often addressed the challenges of technology and has rendered important rulings on digital rights and online abuse. Justice Venkatesh has put theory into practice by ordering the use of AI to help victims of online abuse, by directing law enforcement agencies to take innovative steps, such as cyber patrolling. Justice Venkatesh has often emphasized the need to adapt to technology and ensure that the law does not lag behind. Please put your hands together for Honorable Mr. Justice N. Anand Venkatesh. We are also very fortunate to have Mr. Tushar Mehta, Learned Solicitor General of India. Mr. Mehta is one of the most respected voices in the Indian legal system, appearing regularly in cases of national importance. He has been a strong advocate for improving India's arbitration framework, calling for greater efficiency. On technology, he has spoken about its great promise in easing the burden on courts and arbitrations, while also reminding us that the human judgment and empathy must always remain the central force. Please give a warm round of applause to Mr. Tushar Mehta. We also welcome Mr. Mark Dempsey, Senior Counsel and Independent Arbitrator from the land down under. Mr. Dempsey has more than 40 years of experience in commercial and construction disputes across the Asia Pacific. He has seen arbitration evolve from its traditional avatar to its digital avatar. He is recognized internationally for his legal expertise and sits on panels of major arbitral institutions across the globe. His global experience gives him a unique view of how technology and AI are already being integrated into arbitration in different jurisdictions. Can I please have a huge round of applause for Mr. Mark Dempsey? We also have with us Mr. Tim Lord, King's Counsel, Barrister at Brick Court Chambers, London. Mr. Lord is one of the leading names at the English bar in commercial litigation and arbitration. With over 25 years of practice, he has handled high-profile disputes in finance, energy, and technology sectors. He is consistently ranked among the very best in international arbitration. He has also written and spoken often about the use of AI in arbitration, including its potential in increasing efficiency. Please join me in welcoming Mr. Tim Lord. With such an eminent panel, this session promises to be very insightful. It is now my honor to invite our chair, Honorable Mr. Justice Vikram Nath, to commence the proceedings.
A very warm good morning to everyone present in this auditorium. Honorable judges of the Delhi High Court, for whom I have a lot of respect and affection. Brother judges coming from other different high courts of the country. I can see from Gujarat, from Allahabad. Of course, my panelist, Justice Venkatesh, is from Chennai, Madras High Court. Mr. Tushar Mehta, one of my other panelists, Solicitor General of India. Mark Dempsey, Senior Counsel, and Mr. Tim Lodge, QC. Senior advocates. I also have a very old colleague and friend, Justice Rishikesh Roy, former judge of the Supreme Court. Learned senior advocates, distinguished guests, arbitrators from all over the world. As already informed by the introducer, I have a very distinguished panel today, and we hope to do well and keep you all engaged in this 1.5 hour session on Arbitration 2.0, integration of artificial intelligence and other technologies to enhance the efficiency of arbitration. For this opening remarks, I am standing here. Rest of the session we will conduct sitting there. It is an honor to be here today to discuss Arbitration 2.0, the integration of artificial intelligence and other technologies to enhance the efficiency of arbitration. At first, let me share a story that captures exactly where we stand today. A few days ago, I came across an interesting piece of news. Researchers at Stanford have built what they call a virtual laboratory, a digital space where artificial intelligence systems acted as research colleagues. These artificial minds argued with each other, tested hypotheses, designed experiments, and even developed promising drug samples with minimal human intervention. Now, whether these discoveries stand the test of time is something only careful trials will tell. But the implication is clear. AI can be a powerful assistant, helping humans work faster and more efficiently. It can be a powerful collaborator, accelerating human work in ways we are only beginning to understand. Now, law is not a laboratory science, but that doesn't mean we cannot harness similar tools to revolutionize how we resolve disputes. And that is precisely where Arbitration 2.0 truly begins. Arbitration at its heart was conceived as an answer to the slow grind of traditional litigation. It was evolved as a way to resolve disputes swiftly, efficiently, and with minimal procedure baggage. It is built on the promise of speed, flexibility, and finality. But as the world around us becomes faster, more digital, and more data-driven, even arbitration cannot afford to stand still. This is where the conversation naturally turns to technology, and more specifically to artificial intelligence. If arbitration was designed to save time, then AI has the potential to redefine what time even means in dispute resolution. If you look back at the journey of arbitration, you will see how it has adapted to the needs of its times. The early years were dominated by heavy paper bundles, endless correspondence, and the slow pace of physical hearings. Gradually, we moved to electronic filings, scanned bundles, and online hearings. Today, with AI and other emerging technologies, we stand at the threshold of Arbitration 2.0. Let us think about a scenario where an AI could review a 1,000-page contract in minutes and identify every potential dispute clause. What if machine learning could predict case timelines with 85% accuracy, helping parties plan more effectively? Dear friends, these are not hypothetical scenarios, they are happening now. When we look around, we see leading institutions embracing digital transformation. The Singapore International Arbitration Center has launched its new Gateway platform, designed to digitize and simplify the arbitration case management process. Silicon Valley arbitration and mediation guidelines rest on the core principle that there should be no delegation of decision-making duties to AI. Another issue which is often flagged when technology gets involved in our daily work is that of transparency. The recent Chartered Institute of Arbitrators guidelines categorically mention that whenever an arbitrator intends to use AI tools, he is required to make a disclosure of the same. These are some of the best practices that we can bring back home. Right here in India, we are already witnessing this transformation. In our Supreme Court's Constitution bench hearings, AI-powered systems provide real-time transcription. AI-powered systems provide converting spoken arguments into text as they happen. Machine learning algorithms are translating judgments from English into 18 local languages, dramatically improving access to justice. The Supreme Court is also piloting SUPACE, the Supreme Court Portal Assistance in Court Efficiency. This AI-powered platform analyzes case facts, identifies relevant precedents, and assists with legal research, making our judicial process more efficient and comprehensive. Looking forward, several reforms are necessary to fully realize Arbitration 2.0. The Draft Arbitration and Conciliation Amendment Act 2024 is a welcome development recognizing electronic arbitration, video hearings, and e-filings. Yet, questions around data security, confidentiality, and admissibility of AI-generated evidence remain constant. We still need a robust cybersecurity framework to protect the confidential material stored in the cloud. Platforms that work seamlessly across different arbitration institutions, clear data governance protocols for cross-border disputes, and training programs for arbitrators and counsels. Even with best practices, arbitration is not immune to error, and when not used judiciously, might result in more harm than good. An interesting case which is going on in a court in California tells us exactly what the potential concerns in relying too heavily on AI could be. Here, a party went so far as to challenge an arbitral award on the ground that the arbitrator may have relied on artificial intelligence to draft parts of the decision. The debate was not about technology itself, but about accuracy, transparency, and the integrity of the arbitral process. And that, I believe, is where we must draw a very clear line. Technology can assist, but it cannot take over the role of human judgment. I often say that as exciting as AI and technology are, we must remember that justice is, at its core, human. It requires what I call a heartbeat. Machines can sift through documents, highlight patterns, and even predict outcomes, but they cannot weigh fairness against experience. They cannot temper strict legal logic with human empathy. They cannot understand the difference between what is legally correct and what is truly just. That judgment, that sense of equity, and that moral compass can only reside within human conscience. As it is often said, justice is not the product of intellect alone, but of the human spirit. So as we embrace Arbitration 2.0, let us do so with both optimism and humility. Think of AI not as a replacement for human judgment, but as a powerful research assistant that never sleeps, never overlooks details, and never gets tired of reading documents. Think of it as a translator that breaks down language barriers and an analyst that helps us see patterns we might miss. Technology can make our process sharper, faster, and more efficient, while human judgment ensures that fairness, empathy, and values remain at the core. Each has its role, and together they can strengthen arbitration in ways neither could achieve alone. In that balance lies not just our progress, but the promise of justice that is both modern and timeless. The future of arbitration is being written today. Let us ensure we write it well. Thank you. So before I go back to my chair, will you please display the photographs of all the panelists, which is... Yes. Now see, the organizers have put one of the worst pictures that they have got. I was sitting there and looking at the screen in front. I was got a little frightened. Who is this? They could have found a better picture. I would request them for the next time. Can you see? Is it not a little frightening? So that's a request to the door organizers. Thank you very much. So we now start with the discussion, and we have Justice Venkatesh, Mr. Mehta, Mr. Dempsey, and Mr. Lords. So my first question is to Justice Venkatesh. Apart from generative AI, what are the other technologies that are dominant within the legal fraternity at large, and arbitration in particular? How do you understand the difference between generative AI and other technologies in a way that they affect and or assist with the various tasks revolving around dispensation of legal duties, be it from the perspective of the litigant and counsel representing them, and the adjudicatory body deciding the issue?
Thank you, sir. Good morning to all of you. As you know, arbitration, it evolved from paper-intensive proceedings to digitalized case management. That made the process faster, cheaper, and more reliable. In other words, it made it more efficient. There are a gamut of digital tools, like the digital legal databases, like the one we have for Manupatra, SCC, searching statutes, searching case laws, searching a lot of other guidelines, etc. So this makes it more easier to search. So this is one. Second is the one which everybody is using almost, which is the liquid test and similar applications, where we annotate, we drag anything into anything. From the 1000th page, we just get into the 26th page, so it happens so fast. That's second which happens. Then the instant transcription services. Today, recording of evidence is more like conversation that takes place, if it is used. So we have technology for that, like we have Verbit, CART services, etc. for that. Now comes the artificial intelligence. It's very important to know the difference between a technology which is already prevailing and the artificial intelligence which is getting in. So to put it simply, when I go near a coffee machine and I choose what coffee I want a cappuccino, then I press it, then it prepares it, it gives it. That's a technology. But when I go near it, the machine prepares according to what I want at that point of time. And there you find that artificial intelligence has started working there. So that difference is very important. You want to hear to a song in the morning, depending upon what mood you are, you choose a song in YouTube. But when you go near the system, it chooses a song for you since it has already read your mind, read your pattern, and then it starts playing a particular song in the morning, a particular song in the night. So what happens in a case of this nature is that the artificial intelligence has started deciding as to what we are. It has started reading who we are. So that's the transition between an existing technology and an artificial intelligence. So according to me, artificial intelligence will revolutionize arbitration, and it will not just execute commands. It will anticipate, it will analyze, and sometimes it will also decide. So artificial intelligence as an automated document review, it can prepare chronology of events which is already happening. It can identify gaps in an oral evidence, or else we'll have to sift through papers and heaps of papers. It can test arguments that have been put forth, just to point out which are the main arguments which has to be attended to, which otherwise would take a long time, where you feed everything into the artificial intelligence and it gives you the gaps. It tells you what arguments have to be put forth in a given case. And the final challenge will be AI itself becoming an arbitrator. Is something about which I think the panelists will be discussing going forth. So from being a tool or being a passive supporter, which the technology is already doing, artificial intelligence is going to become an active participant, which will impact the core arbitral functions itself, and it probably will transform the decision-making process itself. So this is my take on that.
Thank you, Justice Venkatesh. My next question goes to Mr. Tim Lord. Yes. So blockchain is increasingly used for secure record keeping, document authentication, and smart contracts that can auto-trigger arbitration on default. In this regard, given blockchain's inherent transparency, how do we reconcile it with arbitration's commitment and statutory requirement regarding confidentiality? Over to Lord. It's all on. It's on. Yes.
Sorry about that. Not a very technical start, so I apologise for the irony of that. Thank you, sir. In terms of blockchains and smart contracts and confidentiality of the arbitration process, I think there are probably three key points. The first is that in the contracts themselves, to which the parties will have signed up, the parties will, in that process, have agreed to this dispute resolution process. So you are probably already building in that degree of agreement, contractual consent to the arbitral process. So that's the first point. There could be difficult questions, I think, as to who the parties are. I can see in that sort of multi-faceted blockchain arrangement that you could have some difficult questions as to who the actual parties are to the relevant dispute, but in principle, there ought not to be any problem. I would say, secondly, it's going to be important for the arbitral panel that hears that case rigorously to endorse and police the confidentiality of the proceedings themselves, given the variegated interests in that blockchain commercial arrangement. And I think, thirdly, it's probably worth noting that there are already well-established exceptions to confidentiality in arbitral proceedings, public interest, the interests of in related proceedings, for example, being two well-known examples. And so whilst confidentiality is integral to any arbitral process, I would have thought that there is enough flexibility in the process for it to be adapted to these really rather new contracts.
Thank you. So now over to Mr. Dempsey. Yeah. AI is already being deployed for tasks such as document review, predictive analytics, and case management across arbitral institutions worldwide. In a preliminary sense, how far and in what ways can AI be integrated into arbitral proceedings to meaningfully reduce delays without compromising due process?
Thank you, sir. Could I start by acknowledging what an honour it is to appear at Delhi Arbitration Weekend, particularly with such an esteemed panel and audience. And if I may commence by saying clearly, this is the one. Clearly the photograph, sir, of you is a deep fake. So I'd like to take the question in three parts: what use could be made, what use should not be made of AI, and how far do we go? So as a matter of principle, I think use could be made, generally, any agreed use, subject to institutional, legislative, and ethical restraints, with appropriate disclosures, such as considered in the Chartered Institute protocol, and some courts, including the Supreme Court of New South Wales, has dealt with the question of disclosure quite thoroughly and in a nuanced way. Subject, of course, as has been mentioned, to the controls on confidentiality, privilege, and so on. Legal research and analysis, obviously, as others have stated already. The rapidity of analysis of large documents is astonishing. And the time and the reduction of time taken in the identification, the collation and preliminary analysis of case or in large projects, whole project records. As we live in the digital age, most large projects are encompassed in a digital record which would take humans forever to analyse. Document preparation and presentation has been mentioned. Forensic use can be made for the identification from a data set, like project records, in a transparent, verifiable manner to establish agreed common facts, for example, and to interrogate, summarise and analyse an agreed data set. For example, in a transparent process by experts in a joint conferral exercise acting under a duty to the arbitration can analyse common facts as a basis for the use of their expert opinions. And that process can be expedited by months using this technology. Submissions and summaries of argument. The New South Wales Court has taken the approach that AI can be used in the preparation of submissions and summaries of argument, provided that there is a verification by counsel that they themselves have checked the accuracy of references to legislation, authorities, and also importantly, evidence. Because unless the parties are required to verify those submissions, places an intolerable burden on the tribunal, and it would be counterproductive to the efficiencies of the arbitral process if tribunals receive submissions created by AI knowing that they could be full of hallucinations and false records. Another aspect where I think it could very well be usefully used is by institutions in two respects. Firstly, in the review of awards. There's nothing more frustrating to parties in an institutional arbitration with the unavailability of tribunal members, etc., to finally get an award and then wait 6 or 12 months for the institution to check and approve the award. That process of checking for consistency, accuracy of citations, and dealing with the various formal criteria for an effective award could be done in minutes or in a very short time, and that could be a considerable saving. There are some respects, however, in my personal view, AI should not be used. Firstly, in the generation of the content or rephrasing of witness evidence, of matters of fact or opinion of which that witness has direct knowledge. Now, this raises one possible point that these days, because the digital record is so all-encompassing, for example, now meetings, project meetings, commercial meetings are conducted by Zoom, recorded and transcribed. In some way, the scope or the necessity for oral evidence, for evidence of a witness of fact to say what they said, heard, did, is in some senses reduced because of the verifiable external digital record. And that record is something that can be rapidly digested and analysed by AI. Secondly, it should not be used for expert evidence without leave or disclosure of the extent to which the factual assumption have been derived and so on. It should not, I don't think AI can be used, as I think in your opening remark, Justice Nath, you suggested, in the reasoning or adjudicative process of the tribunal. Analysis or research done outside the record, outside the submissions of the parties, would clearly goes outside the submission of the parties to the jurisdiction of the tribunal. And that, of course, leads to, it's a delegation of the reasoning and determination, which is likely to lead to problems on enforcement. Of course, there is an exception. The parties are always open to submit their arbitration for decision by an AI process, and there is one such platform already in existence. It's called Arbitration.ai, where the arbitration agreement provides the dispute will be determined by that AI process. How far should this go? the rapid adoption by lawyers and consultants and the courts of AI is very significant, and it's accelerating. Step-by-step oversight by institutions and the courts is occurring, but it's very difficult for courts and institutions to keep up with the rapid development and creation, a continual development of new AI methods. So there is, it is, I think, a step-by-step process.
Right. Thank you, Dempsey. You gave us a lot of multiple ways in which AI can be integrated and be helpful for in arbitration process. Thank you. So now I move over again to Tim. Should arbitral tribunals, specifically those falling under the ambit of institutions, be encouraged to formally adopt AI-powered case management tools such as automated scheduling, transcription, or translation by way of procedural orders?
Thank you, sir. Well, the short answer is yes. Depending on time, I suppose I could go on to give some more reasons, but if you want some more, if you want me to keep things short, then I will. But I suppose just taking it as shortly as I can, these facets of arbitration are quintessentially mechanical. They are fairly mechanical processes rather than what might be described as the more thoughtful aspects of the arbitral process. AI, of course, doesn't think, it predicts. But AI is good at these kind of mechanical predictive tasks. So these really are paradigmatical uses for AI in arbitration. Secondly, it seems to me that typically you'll have an adversarial process unfolding in the arbitration where the parties can be expected to check what the AI assisted procedural orders and transcriptions say, and if there are material errors, they can be expected and even directed to bring those to the tribunal's attention, so that any material inaccuracies are purged from the record as a sort of safeguard. Thirdly, it seems to me that procedural orders are absolutely the right way of going about using AI, because it will enshrine on the face of the proceedings the extent to which AI has in fact been used, which is obviously important for transparency and enforcement. And it allows the tribunal to keep a very strict control on the sort of AI tools being used, how they're being used, the party's responsibility in relation to them, and the costs, the costs of that. And although I better lower my voice now, because I'm going to refer to the Dubai International Arbitration Centre, which in a very hushed tone, which obviously is a much lesser body, doing a bit of research, not AI generated, I hasten to add. It looks as if the Dubai International Arbitration Centre has hooked up with Yus Mundi, which is a sort of AI technology company, to sort of promote their kind of case management type tools. So it looks as if that process is well and truly underway.
Thank you. Thank you, Tim. So now we move on to the solicitor, Mr. Mehta. My question is, in recent cases globally, arbitrators have been criticized for relying on AI, for example, ChatGPT, to draft awards. Should Indian tribunals prohibit the delegation of core adjudicatory functions to AI outright, or regulate it through a disclosure and oversight framework? More so, given that there is the problem of AI hallucinations, such as the use of fake case laws in pleadings awards, and algorithmic bias, which may distort factual or legal analysis in arbitral proceedings. Mr. Mehta.
Thank you, sir. First of all, I'm neither for the AI or use of technology, nor actively against it. But it's too early to take a call on the question of use of AI in any adjudicatory process. Taking the example given by my Lord Justice Venkatesh, that you go to a coffee machine, the coffee machine gives you an option of choosing cappuccino, you choose cappuccino, that is first option, which is use of technology. Out of 5 types of coffees, you choose one. But the AI comes when the machine decides which coffee you are thinking of having. And second, if the technology is so advanced, The machine can scan your body and your other factors and decide which coffee is good for your health. So a machine deciding my choice and machine deciding what should I have has a serious problem, because this discretion is taken away only by the wives and never by the machines. Now, somebody else thinking for you in an adjudicatory process. The question is that use of ChatGPT or any other algorithm, any other medium of artificial intelligence can be used or not. So far, whatever I have studied, I have found that wherever the adjudicatory process involved use of artificial intelligence, it has failed. Not that I am skeptical about it. The technology may advance, but so far, wherever ChatGPT or any other device is used, they have created fake judgments, and fake judgments where in some cases found out, and we do not know, in many cases, the arbitral tribunal or the court may not have found out that the judgment which is being relied upon is a fake judgment. But there is one more serious danger which I have a serious apprehension about. The danger is of algorithmic bias. Recently, there was a study, sir, in US, where artificial intelligence was used for the purpose of judicial adjudication of traffic offenses, the minimum of the category of offenses. And it was found after a detailed study that that particular algorithm which was being used had a bias against colored women. So there were two categories of bias. One, bias based on the color of the individual committing an offense, and second, gender bias. How do you take care of that situation when you put arbitration into the domain of a machine-decided adjudicatory process? So long as we are not very sure about the efficacy of the artificial intelligence, it would be hazardous to replace machines with humans, because there are certain things which only and only humans can do, either as judges or as lawyers, and machines can never replace them. Hallucination, of course, is one problem, but bias is emerging as the second most scary problem, and it's strong, it's fast going to be the first most apprehensive, most problematic part of an artificial intelligence. Because artificial intelligence, ultimately, you take ChatGPT or any other program, is assimilation or collection of whatever material is available in the public domain. You can create that bias in a particular algorithm, and if that algorithm is used, then the litigants are less likely to get justice, till we are very sure that the algorithm which we are using is foolproof.
Thank you, Mr. Mehta. Thank you. Now we come back to Justice Venkatesh. In your view, what regulatory or ethical framework is most urgently needed in India and otherwise to integrate AI into arbitration while safeguarding its fundamental principles, fair hearing, impartiality, and enforceability of awards? Justice Venkatesh.
Recently, I had an opportunity to hear the Chief Justice of Singapore, Mr. Sundaresh Menon of Singapore. He was addressing something akin to this. So he basically highlighted three key areas where technology could help in a better system of administration of justice. One is automation, other is innovation, and other is elimination. Just to elaborate it, automation is authenticating documents, authenticating orders that are relied upon through something which we have as a QR code, etc. So that's one thing which he insists. innovation is innovation in procedures like how you file cases, how you make it online, etc. So you innovate procedural aspects of it. And the third one he talks about is elimination. Elimination is eliminating cumbersome processes. Like today we have online mode of hearing cases, where one need not travel right from Delhi to Madras High Court to come and argue a case before me. You can sit wherever you want to. So basically he identified these three key areas of technology. And however, what is important is that every decision, I completely concur with the Solicitor General on this. Every decision, whether it's judicial or quasi-judicial or executive, which directly affects the rights of the parties, it requires application of mind, recording of reasons. These are things where there can never be a compromise at all. So this is never compromised by substituting an artificial intelligence into it. So an artificial intelligence, in short, can supplement the work of a human judge, but it can never supplant it. That's the most important thing. Having said that, coming to the question that has been posed to me, I think the core framework requirements for that will be, in every area where artificial intelligence is going to be used, human oversight requirements must be made mandatory. Number one. Second, impartiality will have to be, as was addressed by the Solicitor General, impartiality is something which has to be assured. So, for instance, they use this COMPAS, C-O-M-P-A-S, in USA. This is a mechanism where the artificial intelligence takes in the facts that are put in and decides on a bail. What happened was that every time, in the famous case is the Wisconsin case, where this Wisconsin case where it was proved that every time it was a black man, the artificial intelligence thought that he is a person who will repeatedly commit offenses. So therefore, in most of the cases, the judgment was going against the black man. So that's something which the Solicitor General was also addressing. So the third important thing is that it should be ensured that there is no partiality. It should be impartial. Third is the most important thing which Lord had pointed out. This is about confidentiality and data security. Why? Because what you are feeding into the artificial intelligence is something which is owned by a third party. So therefore, things will get into the hands of a third party, and where in a era where artificial or the rights which are intangible rights, which are very important and confidential, which makes or breaks a business. So if this confidentiality is going to be compromised, so confidentiality and data security is very important. So these three areas are very important. Number one, what do you do for it? There are certain guidelines which are already available in international standards, which was addressed. This is the European Union Artificial Intelligence Act, is something which has addressed it. Then you have the AAA guidelines, you have the SVAMC guidelines. Then what is important finally is that after having all these things, it's important that you establish an AI review body which must consist of a legal, an ethical, and a technical expert to audit and recommend the remedies for it. That's very important.
Thank you. Thank you, brother. Now I move on to Mark again. Should arbitral institutions in India adopt guidelines similar to the Silicon Valley Arbitration and Mediation Center and Chartered Institute of Arbitrators guidelines, that is the CIRB AI guidelines, requiring disclosure whenever AI tools are used in drafting submissions, reviewing evidence, or preparing awards?
Thank you, sir. I'll deal with that question in three parts. Submissions, I've addressed earlier, and I'll let my remarks stop there. Reviewing evidence has two aspects. One party reviewing the evidence and submissions of the other party, as Mr. Lord has mentioned, being an adversarial process, and as recognised by the CIRB guidelines, any one party can use AI tools to do whatever it wants in its own internal work. But when we go from the reviewing of evidence and preparing awards by the tribunal, we get into a vastly different and more difficult process. Supposing we're searching thousands of pages of evidence to establish 3 facts. The AI tools which look for patterns and they're not repeatable. If I as arbitrator want to establish when a particular activity was finished on a particular project, by whom, I could run a search from the arbitral record and get one result. If I did it the next day, I could get a different result. And so if I was, as a tribunal, were to accept the result of an AI analysis as a fact upon which it proceeded to base its judgment, the whole award would be infected by error from the outset. Now, of course, part of the efficiency and purpose of the New York Convention system, it works because there's no judicial review of fact-finding and legal finding. That is because of the trust that the parties have through the institution of the tribunal, that tribunal can be relied upon to find facts in a reasonably reliable and responsible way. So if a tribunal were to use AI in fact-finding, let alone reasoning, it would undermine the basis of trust in the arbitral system, and it wouldn't work. So guidelines are very important. The real difficulty I see is what guidelines can be given about to tribunals about use and disclosure. And I see a huge problem. If a tribunal undertakes through the procedural order that it will give disclosure of what use it made of AI during the fact-finding and adjudicative process, that would lead to the exposure of the arbitral adjudicative process, which would then open up for investigation and delay enforcement, not only in the meritorious case, but quite often unsuccessful arbitral parties challenge, and they do so in an opportunistic way. One other problem of AI is it can produce what looks like the world's best judgment in perfect language and apparently clear reasoning. It's very difficult to disprove a negative proposition. Any unsuccessful party could say that award has been created in whole or part by AI, and then seek in the review process for disclosure of what use the tribunal made. And as I suggest, and I think is obviously apparent, that would be a disaster. So at this point, it would be one safe way to proceed, it seems to me, is to all of the formal, procedural, non-contentious stuff like procedural histories and so on, if they are produced by the tribunal and given to the parties pre-award, then the parties have an opportunity to test it. And one thing, an AI-generated result can be easily tested. So that way, I would require that any use by the tribunal or the other parties be exposed and subject to analysis prior to the commencement of the adjudicative process. And so I see real difficulties in how and what a tribunal would disclose without creating problems.
Thank you. Thank you. Now I come back to Mr. Mehta. Who bears the responsibility if AI-assisted work leads to errors in the arbitration? The party using it, the arbitrator relying on it, or the institution administering the case? Should arbitral institutions consider a liability framework or safe harbor provisions for arbitrators when AI is used in good faith but proves flawed?
Yes, sir. Thank you, sir. So that is the real problem which is troubling me while even answering this question. When we use technology in many ways, forget artificial intelligence, for example, technology is used for the purpose of translation. But there is a translator who takes the responsibility if there is a wrong translation, either advertently or inadvertently. There are several other dimensions of an adjudicatory process where you make use of the technology, but there is someone where the blame would lie. While using artificial intelligence either in the adjudicatory process or in the process of gathering evidence or leading evidence or even while preparing the submissions, whichever artificial intelligence output or whatever a ChatGPT or I'm not aware what is that, whatever is used, it ultimately takes from what is available in the open web. So even the agency, ChatGPT or anyone else, also cannot take the can take the responsibility. For example, Wikipedia, earlier it used to be cited very often in courts. Thereafter it was found that it can be edited easily. So now Wikipedia is not cited. In absence of any accountability, it is not safe to use artificial intelligence. And as Justice Venkatesh has very rightly said, I would put it this way, that it can be a assistant, not a master. It can be an apprentice kind of a device, not an adjudicatory device. So long as there is a responsibility place which can be reached. So let it not control the system, let it assist the system. Rather than supplementing, it can supplant. But there is already a good faith clause, there is already a safe harbor. But even if that safe harbor is given, say to arbitrators, would we give that safe harbor to lawyers as well? The reason is that the lawyers also prepare their written submissions based upon ChatGPT or any other format. And it is found that there are hallucinated or fake cases which are being cited. Would there be any safe harbor for a lawyer if he cites a fake case and say that I relied upon some artificial intelligence device and that resulted into my citing a fake case? Answer would be no. Because it is only the adjudicator who gets the safe harbor. The lawyer's responsibility is not taken away. So I think rather than being either techno-romantic or technoceptive, we should wait and see how the technology grows. And if we can reach a stage where we can fix the responsibility of the source and we can trust the adjudicatory mechanism through artificial intelligence, we should wait. But in this entire debate and discussion, we are forgetting one thing. The focal point of any adjudicatory process is the litigant. My question to myself is, as a litigant, when there is a party autonomy, would I trust a machine deciding my dispute being adjudicated? If the answer is no, then why are we discussing this at all? The litigant may not choose a machine to decide. He would feel safe that a human mind is applied, a human mind is assisted on my behalf, and a human mind will take care of the equity, which will take care of empathy, which will take care of reading between the lines, takes a call and adjudicate my dispute. So this entire debate possibly inadvertently ignores the focal point of the adjudicatory process, and that is the litigant.
Thank you, Mr. Mehta. So now coming back to Tim. The Chartered Institute of Arbitrators guidelines flag risks of inequality of arms if one party uses sophisticated AI tools and the other does not? In such a situation, is there a need for arbitral tribunals to step in to ensure procedural fairness, and if so, how?
Thank you, sir. I think the first point in response is to note that inequality of arms arises now with the use of human intelligence, because there's very often inequity in terms of the human resource that is massed to represent different parties. The size and strength of the legal teams can vary. There isn't really a terribly effective way at the moment of regulating that, because obviously by definition that would involve interrogation of confidential, privileged matters and the inputs into each side's internal legal teamwork and preparation. The only really safeguard at the moment that I can think of is costs, but that doesn't tend to deter the well-resourced litigant from arming up to win the case, even if they don't recover the costs for all their competent counsel. So I think that's the first point. Secondly, and at the risk of, I wouldn't describe myself as an AI enthusiast, but I feel like I'm being cast as that. But the second point probably is that AI might actually help bridge this resource gap. Because in fact, what AI might bring to the party, if I may respectfully suggest, is the ability for a less resourced litigant to augment its legal firepower with some of the artificial intelligence to try.
Thank you, sir. So confidentiality of individual, confidentiality of the information both. What ultimately these big giants, Facebook, etc. are doing, what is their source of income? Are they manufacturing anything? No. Are they into production? No. Are they running any industry? No. We rent our mind to them and pay the rent to them. They make an addictive algorithm and they capture everything and sell what we think to others. And that is where the question of confidentiality comes. Now, confidentiality in this sphere, in this medium, is impossible to achieve. Even if there is a statutory regulation, then confidentiality can never be ensured unless and until we reach a stage where technology is so developed that the confidentiality can be achieved. Confidentiality can never be achieved by any statutory regulation or even prohibition. That factor will have to be borne in mind by whoever takes the decision about the use of artificial intelligence, that it will not remain confidential.
Thank you, Mr. Mehta. Continuing on this confidentiality and data protection, I would now pose my next question to Justice Venkatesh. Would it be appropriate to certify certain AI platforms for arbitration use, similar to how courts vet e-filing systems? In this regard, would it be prudent and in the interest of justice for arbitral institutes to have their respective AI-related rules, guidelines, or to have a nationwide set of rules, guidelines to be deployed by arbitral institutes?
Yes. It's a two-pronged action which has to be taken. One is the arbitral institutes must develop AI-related rules and guidelines that must basically codify the certification, standards, delineating clear requirements for disclosure, consent, auditability, and accountability in AI use within arbitration. That codification is required. And to ensure that there is uniformity across the nation, a set of AI rules or guidelines is required. This will become more important where it is cross-institutional or it deals with international disputes. So, a hybrid approach is desirable here. Then, what is that the certification must include? That's the next question. What is that it has to include? One is, as is repeatedly said, bias testing and validation is a must insofar as codification and testing is concerned. Second is compliance with data protection rules. And third is, it must always be remembered that AI does not think. AI only predicts certain things based on the data that has been collected by it. So AI tool is always prone to error, at least to my limited understanding till now. There is nothing called as 100% which is available. So AI tool is not prone to error. Is prone to error is something which has to be factored. Okay, what is available in terms of codification that should be done from the institutional level or from the nation level? What is available is what I said earlier. There is something called as the European Union Artificial Intelligence Act 2024, which it designates artificial intelligence used in administration of justice and ADR. So that's one thing which is available. But the most funny part is that that act says that it's a high risk category. That's the act itself says that it has brought it within the category of a high risk category, and it does not create this act does not create any arbitration specific rules. So, but it gives an overall idea. Then you have court specific practice directions that are given by courts. For instance, you have one such thing in the King's Bench in Manitoba, Canada, where guidelines were given in 2023. So those guidelines says that if artificial intelligence is used in preparation of materials, then it must indicate how it was used. So that's something about which it is insisting. Those are guidelines, practice guidelines given by courts. Then what you have is something which all of you have prone to error in the usage of AI in that process. So if that is done, and it is done with a hybrid approach, both from the side of the institution as well as the country, it will work well.
Thank you, brother. Thank you. Coming back to Tim, arbitration depends heavily on confidentiality, with AI platforms often trained on large data sets and cloud-based infrastructures. What safeguards should arbitral practice adopt to prevent breaches of confidentiality and data protection?
Thank you, sir. I think the answer probably is that the safeguards would ideally operate at two levels. First, as to the selection and design of the relevant AI tool, and secondly, as to the control exercised by the tribunal over the use of any such tool. As to the first point, it's obviously important that the AI tool being used is not a public or open source one. In other words, that you upgrade to what's called the enterprise level subscription for AI tools, which invests the use with confidentiality, which means that the material that is essentially ingested and interrogated by the AI tool does not then form part of the general archive of material available for the LLM to keep learning on. So that way you can actually keep the arbitral archive of documents confidential and use the LLM to interrogate, like to hunt down the answer, leave the archive and go back to its kennel, as it were, to use a kind of dog analogy. And I think it's important perhaps to note here, in terms of confidentiality, that all lawyers around the world readily use Word and email, often in the Office suite hosted by Microsoft. We are all trusting every minute of the day Microsoft to respect the confidentiality and data protection requirements. And I think if you analyse what we're talking about here with the AI, I think it is in the same ballpark. So as part of that, it's probably wise for the arbitral tribunal to have a sort of data processing agreement with the AI providers to make sure that the safeguards for confidentiality and data protection are expressly and transparently built into those proceedings for all to see. So that's the first level. And then the second level is obviously the tribunal need to make sure that the use of AI is controlled so that it respects the confidential functions, who can access it, how it's to be accessed, how it's to be used, and what functions are not to be used by anybody privy to that arbitration. So with those ingredients, one ought to be able to address confidentiality.
Thank you. Thank you. So now we move on to Mark. Should parties by agreement and tribunals be permitted to mandate the use of only jurisdiction-specific or institution-certified AI tools to ensure compliance with data privacy norms?
So I think the rate of development of the AI tools and specific tools for particular types of disputes is so rapidly developing. It's hard to see how an institution could reliably adopt a specific tool for use without restricting, without locking the tool in time. So I think I see that one practical difficulty in that course.
Thank you. You want to add something? Yeah.
No, it's fine. Yeah.
All right. So, Mr. Mehta, I'll not make anyone, take a nap or something. I'll keep on.
No, I'm completely agile, sir.
Should tribunals permit AI-generated evidence, translations, summaries, or forensic outputs? And if so, can they be treated on the same footing as human-prepared evidence? If yes, what threshold of reliability and verification should be required before admitting such material into the record?
Yes, sir. Thank you, sir. So far as use of artificial intelligence in evidence taking or translation or any other such help is concerned, there is no difficulty so long as you have someone to put the blame on. And when I say blame on means someone is there to take the responsibility of an error. Anything beyond would run the risk of party not feeling that it has got the justice. Because here the one element which comes to my mind is that it's not only that the justice we say should be done, but should be seen to be done. Even an apprehension that the judge did not apply his judicial mind itself is negation of rule of law. Now what happened in case of La Pegalia, I think, versus Valve Corporation, it's a recent judgment, where the arbitrator was in a hurry and he was asking the parties to hurry up, saying that after a week or so, he is to travel for a vacation for a week or two. And the parties, as the lawyers do not have much of an option, they hurried and the arguments were concluded. Immediately after the vacation was over, he declared his award. And the challenge to the award is inter alia on the ground that the speed with which the award has come, despite the documents running into few thousand pages, the party has a serious apprehension that the arbitrator has used the artificial intelligence tool. Now that's the question. That's the question yet to be finally adjudicated. The similar question is being faced by other courts also. I'm told High Court of England had faced this question and has laid down certain guidelines. But the guidelines are also cannot be by its very nature exhaustive. They are only illustrative. Question is, if we permit artificial intelligence either for adjudicatory function or for the function of a lawyer, which is, as the question suggests, leading of the evidence, would the party get the satisfaction of having got justice, even if he loses? Even if a litigant loses, he should get the satisfaction that he had his day in the court or before the arbitral tribunal. So, my personal view is this AI tools can be used for the purpose of assimilation of evidence. It can be used for the purpose of things like logistic purposes like translation, any assistance, logistic assistance required to the arbitrator, but not what I call the core areas of adjudication on the part of the arbitrator and core areas which are necessary for the lawyer to give his input. Except these two sacred areas, AI can always be tested to be used till it is found that it is trustworthy or not trustworthy.
Thank you. Mark. If arbitrators use AI to assist in drafting procedural orders or even sections of an award, should this be disclosed to the parties? Would non-disclosure amount to a breach of the arbitrator's duty of fairness and transparency, or is it akin to relying on a secretary or research assistant?
To give that question context, it's been the practice of courts and tribunals in the past have research staff, research the law, prepare summaries, even draft sections of an award perhaps of an administrative nature, and that's generally regarded as being permissible. But there's a fundamental distinction at play because the tribunal secretary, who is appointed with the consent of the parties, is no doubt or presumably a highly trained and reliable lawyer with legal analytical skills. And the product of, there is no equivalence between the product of a research of a tribunal secretary or administrative drafting of a tribunal secretary than the product of LLM tool, which just seeks patents. So that's one key distinction. Again, the difficulty I think that has been mentioned by a number of us is there's just no bright line where fact finding begins and ends, and the post-hearing unchecked product of AI by the arbitrator in the award process seems to me to pose huge problems, as would disclosure of such use.
Thank you. Thank you. So now we come back to Justice Venkatesh. Both guidelines, CIRB and SUNC, note the dangers of algorithmic bias and hallucinations, fabricated outputs presented as fact. They also caution that awards tainted by unverified AI use may face enforceability challenges under the New York Convention. In such a scenario, how should Indian courts entertain Section 34 of the Arbitration and Conciliation Act challenges where a party alleges that an award was improperly influenced by AI? Which ground under Section 34 would such a challenge emerge from?
In legal parlance, we have heard something called as ghostwriters. Reading some judgments, we know that it's not that person who wrote the judgment.
Sometimes we feel that it's better he has not written.
So one of the top managerial person who is my friend recently spoke with me, and he said that the fellow does not know to write one full sentence of English, and he submits me a resignation letter which was at such a level that I immediately accepted the resignation. So it's possible that just by reading it many a times we'll understand whether it's that person who wrote it or the artificial intelligence was behind it. Because nowadays, many of the articles, many of the things which are coming into the public domain, we find a lot of perfection in grammar, lot of perfection in the sentence formations, which that person is incapable of. So, having this in our mind, I would say that the present Section 34, which very commonly we say that there are 8 pigeonholes, and in one judgment I said that there are 8 pigeonholes under 34, even through which even a sparrow cannot enter. It's that tough to really challenge an arbitral award in India, right? So here, I would say that an award must not be set aside merely because the arbitrator has used the assistance of an artificial intelligence in terms of he has applied his mind. The problem with the artificial intelligence influenced award will be that artificial intelligence may decide the case without reference to the argued position itself. And if the arbitrator carries forward these findings without even aware of it, and without verifying it, and without putting it to the parties, which they never argued before the arbitrator, the award is basically something which has to be set aside on this principle. So that's something which is inbuilt, which is available even for, available under Section 34 of the Act. The next thing is the mandatory provisions of a statute. For instance, we will find artificial intelligence platforms, at least with the current level of developments, which is not perfect as I am saying right from the beginning. It makes multiple mistakes on legal issues and its interpretation of understanding a precedent. Because precedent is not 1 + 1 = 2. Precedent is based on the facts under which that precedent came in. That may not be an area where artificial intelligence can really get into it and understand it in that way. So, such a conclusion that is arrived at by an artificial intelligence, that will make it susceptible for challenge under 34. That's the other thing. Second is, there is a ground called as violation of the most basic notions of justice. That's something which is available under 34. So, an artificial intelligence platform can end up granting relief that were not even prayed for. That has happened in some of the cases. So, resulting in the award itself becoming susceptible to challenge. The next one will be the patent illegality test, which we have under Section 34(2)(a) of the Act. So, that patent illegality test will come where there is an unintelligible reasoning. As you all must be knowing, the experts here, the Dyno technologies, the three-pronged approach of how we deal with it. So, where the reasoning itself is unintelligible, it by itself will become susceptible for setting it aside under 34, or ignoring the vital evidence of an award. This will be the most common ground which will be attracted, according to me, as on today, because the current artificial intelligence platforms have only 60 to 70% efficiency as is available.
Thank you, sir. Well, at the risk of a little digression or context, I always have some sympathy when I hear of the hallucination of the AI jurist, because as a KC of slightly advancing years, I catch myself sometimes in a consultation saying to my hapless juniors, I think there's a case on this. Yeah. And there turns out not to be. Two of them are very loyally come in the audience. Chinthan Chandrachud and Firdaus Mohandas are in the audience, and they will attest to that. The second, I think, quick contextual point is that there is delegation now within the existing human legal framework of quite a bit of important work. A KC trusts his junior counsel. A partner in a law firm trusts an associate to prepare a first draft, and dare I say even a judicial assistant will help often with the tribunal. And I think the third contextual point is that in very complex commercial cases, big commercial cases of the sort that we see out here, they're in the end, in all those cases, they tend to resolve on a handful of key points. So no matter how much material seems to come into play, relevant to the dispute, ultimately there's a handful of key issues. And I wonder whether the commercial men and women who use the arbitral process would not quite welcome focusing the foreground and the background. And there are important background issues that need to be correctly adumbrated, but which I find, sitting as an arbitrator, take an awful long time to rehearse. So there might be a 100-page award. It might take 2 weeks to do the 95 pages that no one's really very interested in. And actually, there's 5 really crucial pages at the end. So in terms of the question, I think the key word is influence, because obviously what cannot happen is that you substitute the AI tool's decision or judgment for the arbitral panel's decision. That absolutely cannot happen. But the EU AI Act requires effective human oversight of high-risk AI systems. So what that really requires, I think, with respect in this context, is that the arbitral panel carry out the proper and thorough oversight of whatever that they have actually received. And if they do that, then they're all in principle to be no problem. And it just I know we're nearly up in time, but just to counter the idea that the English are stuffy, which I'm sure they probably are, but it's probably worth just noting that there is in the judicial guidance for AI issued in April of this year to the English judges. It's probably worth noting this. It says this: take responsibility. Judicial office holders are personally responsible for material which is produced in their name. Judges are not generally obliged to describe the research or preparatory work which may have been done in order to produce a judgment. Provided these guidelines are appropriately followed, there is no reason why generative AI could not be a potentially useful secondary tool. So on that rather thought-provoking note, I think I'll stop there. Thank you, sir.
Thank you, Tim. Thank you so much. So we are already on time and all the questions are over. Mr. Mehta is requested for a 2-minute additional. I can't refuse to him.
I just, to end on a lighter note, there was one eminent and very popular novelist, but it used in America, it was used to be believed that somebody else writes his novels. It was quite popular thing, like it is popular at Justice. I'm not quoting him, but it is quite popular for some judges also. So once he told his friend that one of my latest novel is on the market now. Have you read it? The friend asked him that, how is it? Have you read it? One of the judges who retired, not very before a few years, he had written a very brilliant judgment. And one of my colleagues asked that, how do you find this judgment? I said, I'll not accuse him of having written this judgment. He said, but do you think he may have read it before signing it? And I said, no, he would read it when in a next case before him, we will start reading that judgment and relying upon it. And thank you so much.
So we are almost, time is over. We had thought that we could spare some 10-15 minutes for some open house questions coming from the audience. Maybe 1 or 2 questions. Is that okay? All right. 1 or 2 questions. Yes, Mr. Garg. The question should be short, yes, and the answer should also be short. Yes.
Answer is not in my answer. My name is Shashank Garg. I'm a practitioner in Delhi. I have a very brief comment and a very brief question. The comment is, in fact, on the picture. I've been given to understand, and I agree with Justice Nath, that it's not half as charming as he actually is. But the fault lies with the Supreme Court. This has been taken from the website. Now coming to the question, and I think...
But did you like this picture? So you could have picked up another picture. Nobody stopped you that you have to take an official.
No, so we tried putting something else, but AI kept telling us that the Supreme Court website has this picture. But coming to the question, sir, now as a judge of the Supreme Court or as an institution...
No, I'm not supposed to answer questions. The panelists are supposed to. You have to put your question to the panelists.
Sir, so any panelist can take this up. Would it be...
Say, I put this question to myself, then only judges answer.
I'll take a cue from the learned solicitor.
You must always take it from his experience, huh? Yes.
Thinking aloud, I wonder if a judgment comes to the apex court and the judge has, in fact, of the High Court or whichever court the judgment has been appealed from, has used AI only as a tool and it is disclosed. Would that also be troublesome for the apex court, that if AI is being only used as a tool, maybe to correct the grammar, maybe to assist in research, but ultimately...
I don't think that should be a problem at all.
Ultimately, it has the
And that will depend upon judge to judge. Some judge may have a problem with that, the others may not. I will not have a problem if you disclose that you have used AI tool in drafting your judgment to make it better. Nothing wrong in that.
But would a disclosure is
But if you say that the decision has been taken by the AI as to what should be the conclusion, then there is a problem.
The party may have a problem. The
So
litigant may have a problem.
even if the research and the language assistance has been taken by AI, but the ultimate decision is of the judge, and that's also disclosed, would that be something that would be acceptable to start with in terms of letting AI come in the system? That's my question.
Let me frankly tell you one thing. Earlier it used to be good stenos. Probably it will be taken over by AI. So there are some brilliant stenos who will make up the grammatical mistakes.
If I would have been a
Formation of
judge,
sentence.
sir, if I would have been a judge and the litigant complains
Yes.
that the judge has merely used it for the purpose of correcting the grammar and the
Yes.
language,
Yes.
I would tell him that you should thank himself. It's party autonomy. You should have selected an arbitrator who at least knows the language properly.
All right. So, thank you everyone. You have a question? All right. Please pass on the mic. Because if we delay, every other session gets delayed. So,
Sorry,
short
I just
question.
wanted to check if your lordships feel that we can use AI for procedural matters like a 29A extension, and there can be some guidelines to that to save judicial time.
Brother Venkatesh to answer.
Even in a 29A, there is a particular peculiar words used where there is sufficient reason for the court to extend the time. So who decides that? Whether the AI decides it or the court decides it. Even in 11.6 or 11.5, which is now the Supreme Court says that you'll have to just look at the agreement and you'll have to see whether the agreement is in line with Section 7. That's the only thing you can do. Even there are lots of things which the judge has to decide. So from outside it will look like a completely administrative act. But then there is some application of mind involved. So as was rightly said, wherever there is reasons that has to be assigned, wherever there has to be application of mind, it should never be bartered to artificial intelligence in the present scenario.
Thank you. So we now come to a close of this session. Let me first thank DAW and DIAC for giving us this opportunity of so much of learning and such good discussions. I must thank all my panelists for the inputs that they have given to all of us. We have all gained from it. And lastly, I would thank Mr. Shivang Diddi, who was the coordinator, and he did a meticulous job in, coordinating all 5 of us from different countries and different time zones, so that we could come to an agreement as to how to proceed with this session. Thank you very much.
Can we have a huge round of applause? May I now request Honorable Mr. Justice Subramaniam Prasad to present our chair and panelists with a Prabhavali. A Prabhavali is a traditional ornamental arc crafted in intricate brasswork, symbolizing India's rich heritage of craftsmanship and cultural expression. Set against a backdrop of hand-woven Indian textile, it reflects the country's enduring tradition of artistry and design. We hope it serves as a meaningful reminder of your time at the Delhi Arbitration Weekend 2025 and of the timeless elegance of Indian craftsmanship.
Thank you very much. Thank you, sir.
Can I have a huge round of applause for our panel?
Thanks, Justice. Thank you.
With that, we come to the end of this session. Our next session, session 2, will begin shortly. Thank you.